the other thing I want to get into here now, you've covered the sort of legal side of this pretty well and some of the potential outcomes. One thing I want to discuss too, because this was another area of broad agreement among a lot of the experts that I talked to, is the effect of realpolitik on this whole thing, right? There's an assumption that perhaps, justices like Kavanaugh and Roberts, who wrote a concurrence in Bruin that sort of reemphasized the idea that shall issue gun carry permitting is okay under the standard without actually going through and doing the historical test set out in Bruin to back that claim up. That Barrett has previously in Cantor, expressed her opinion. Now, obviously, Cantor, her opinion is mostly about why nonviolent felons should not be prohibited, but she does briefly talk about why violent felons ought to be. And so perhaps she'll have some inclination to want to prevent domestic violence perpetrators from obtaining firearms. How much of an impact do you expect to see those sorts of considerations to have on the court? Because one thing I've always talked about with these landmark decisions they've handed down is, they're pretty far behind public opinion in most of these cases to this point. Heller was about whether or not the practical question was about whether or not you could totally ban handguns, but that by that point in time, almost nobody had a total handgun ban, right? It was DC and Chicago basically were the only ones left. Same thing for Bruin in a sense, right? It used to be that concealed carry was widely banned throughout the country, but by the time the court said you can't do this, you can't at least have subjective measures for issuing permits, it was already the case that politically the country had shifted dramatically on the question towards allowing permissive gun carry, concealed carry legislation to be put in place. We haven't seen that same shift on domestic violence, obviously. I think most people agree that domestic abusers shouldn't have firearms. Maybe there's a different point of view about the specific point on restraining orders and the sort of due process protections afforded by them. But, how much do you expect politics to play a role in this?
Well, I think there's multiple answers to that. And this is going to get, like I like to say on the channel, right, super geeky about inside Supreme Court world. To begin with, this court has shown a lot of courage, if you think about it. In the last couple years, what has this court done? First of all, they issued Bruin that knocked out these may issue permitting regimes. That was just an act of courage to follow the Constitution, despite the mainstream media attacking them relentlessly. They overturned Roe v. Wade. That's a big deal, right? That is not, you can disagree with it, you can like it, whatever you want. The fact is, it took courage to overturn Roe v. Wade. They knocked out affirmative action in universities, right? They have done these sorts of things that run against what the mainstream media in DC and New York, that can buy ink by the gallons, as they used to say, attack the Supreme Court relentlessly. Now, so that's the first thing. There is a lot of evidence that this court, and don't forget, of course, the Biden student loan forgiveness program was knocked out. So this court has shown a lot of courage in a lot of areas. That's the first thing. They've shown backbone. Now, this is where we're going to get geeky. There are aspects of American law that are littered with left-wing Supreme Court precedents that are very difficult to get rid of. These are barnacles on our constitutional system brought to us by 50 years of judicial activism, starting in the 40s, the 50s, the 60s, and the 70s, that for a court today to do things like involving, let's say, the Voting Rights Act, Section 2, to deal with some other aspects of American life, not only would the Supreme Court have to basically reverse course of what the Supreme Court has done in the past, it literally would have to take all those dozens of Supreme Court precedents and sweep them into the trash bin of history. which is very difficult from a practical point of view. Even if it's the right thing to do, there is some there is some practical realities of, for example, the Miranda warnings are with us. They're not going anywhere. And that's just where the law is now. And as a matter of precedent, you can't really get rid of it that easily. Now, here is the good news, Stephen, when it comes to our Second Amendment. The great benefit of the American barristas not being able to do enough stuff and not having that many Second Amendment cases is this. The United States Supreme Court, when they do their Second Amendment jurisprudence writings, guess what? They're largely writing on a blank slate. Because unlike, for example, First Amendment jurisprudence, free press jurisprudence, Fourth Amendment jurisprudence, Eighth Amendment death penalty jurisprudence, of which there are dozens and dozens and dozens of cases that you have to write around and distinguish and say this is not relevant or this is relevant or we got to overturn it. Guess what? In the context of the Second Amendment, Stephen, you don't have any cases like that are adopted by liberals that you have to distinguish or get out of the way. You're literally writing on a blank slate if you're the Supreme Court involving the Second Amendment, because you're really just applying Heller and Bruin, and then to some degree Caetano in a gun ban case, and maybe some aspects of Miller, but not really at this point. So you're really looking at two Supreme Court cases, plus Caetano and maybe a little Miller, and that's it. That's it. That is a lot easier to get the Second Amendment right as a matter of originalism. I mean, what did the Founding Fathers intend by their words? Because there's none of these anti-Second Amendment legal precedents by the Supreme Court that has to be wiped away or distinguished or whatever, which is the reason why I say this is that's why I think, for example, if you look at the Kavanaugh and Roberts decision to not knock out Section 2 of the Voting Rights Act in the Alabama case a few weeks ago that a lot of conservatives are upset about. But if you look at what Kavanaugh and Roberts are writing, they said, look, we have like decades of this precedent involving the Voting Rights Act, and we don't really want to blow it up. It's just, because it's there and everybody's been living under it. And they kind of like went along with it. But that is not the sort of thing that Roberts and Kavanaugh are going to have to do in the context of the Second Amendment. So I think that, yes, we can all criticize Supreme Court justices for all sorts of things, and they're fair game, just like, our presidents are. But I do ultimately am optimistic. Remember, the Supreme Court did give us Bruin a year ago. And if Merrick Garland thinks they're going to somehow screw that up and do an about face, I don't think that's going to happen. And the only thing I also want to mention, this is another thing that I don't think anybody else has noticed. So I'm going to let you know and your viewers know, because the reload is great and I hope they all subscribe to it, is this. There's a case out there that I'm going to look very carefully at when Amy Coney Barrett was on the Seventh Circuit Court of Appeals. We always talk about Cantor versus Barr, which, of course, is the nonviolent felon case. And that's legit. I talked about her dissent in Cantor versus Barr on Fox News repeatedly during her confirmation hearing. But there's another case that Justice Barrett was involved with when she was a judge. And I want to look carefully at this. This involved Title IX. What is Title IX? Title IX is the federal law that has certain restrictions and rules on universities in various ways, including you can't discriminate on the basis of sex. Now, the reason why this is important, as I recall, Justice Barrett actually issued favorable rulings and a very civil procedural rulings involving people that were accused of wrongdoing on college campuses. And as I recall, she came out with very robust language in favor of you can't punish people, kick them off campus, do things like this, unless you really follow very strict due process rules, because it's otherwise not fair. So I think when it comes to these process concerns, Justice Barrett could play a very big role in discussing, well, yeah, maybe if someone is dangerous, you can take away their gun rights, but how do we prove it and what needs to be shown? And the government can't just wave a magic wand and say, we don't like that person because if they like Donald Trump, we're going to take away their gun rights. No, it has to be a lot more than that. And I think we should look very carefully at Justice Barrett and her jurisprudence, because she may play a big role in whether or not a restraining order just rubber stamped by some court out there in the middle of, the middle of the country, if that's enough to cause someone to lose their fundamental textual constitutional right to keep and bear arms.
Yeah, I mean, I really do think the process questions are going to be bigger than people assume. Certainly I don't think anyone wants to see domestic abusers be able to have guns. But I also, on the other side of that question, the other practical sort of aspect that may play a role in the opposite direction is kind of the fact that Rahimi is such a bad guy, or at least accused of being such a bad guy. that he's very likely to end up in jail and without his gun rights anyway, regardless of what happens with this case, right? Do you think that perhaps will play a role too?
Yeah, I mean, again, once you start talking
Maybe
about
lowers
things
the stakes a
other
little bit. I don't for these justices. I don't
well,
know.
look, if you think about it, if you assume, and I don't think we should be assuming, but if you were to assume that the U.S. Supreme Court justices are going to start to look at the newspapers to determine how they're going to rule on the case. If you assume that's what's happening, and I don't think that's really what's going on here, I don't think that's going to happen here, then certainly they would be aware that, let's say, if Mr. Rahimi, is convicted and sentenced to jail for 30 years for some other crime of one of those other shootings, then I guess the Supreme Court would be like, well, we don't have to bend over backwards to make sure Mr. Rahimi is going to prison because he's already in prison in some other court or for some other crime for 30 years. So, you could conceivably say, well, what's the point? Again, I don't think that's what the Supreme Court does. I don't think they look into those things. I think they really take their job as originalists, which means you look at the text of the Constitution and the relevant history to try to get it right. I don't think they're going to deviate from that because I think they take their jobs very seriously.